All right, we are live.
Okay, good morning. This is Senate Natural Resources and Energy, and it is Wednesday, February 18th. And we have a variety of topics to chat through today. So we are going to start with S224. We have a few folks from the city of Barrie joining us this morning. I think we're just going to go right down the list. Again, just the context for this, this is related to the fishing tournament portion of the bill, that issue. And so we're gonna start with Mr. Dufresne. He's the principal in charge of design and construction management for the city of Barrie. Welcome.
Good to be here. Good morning, everybody.
Good morning. Actually, maybe let's take a quick second to introduce ourselves, and then if you wouldn't mind introducing yourself, and then tell us what you'd like us to know.
Sure.
Okay, good morning, Mr. Dufresne. I'm Senator Ruth Hardy from the Addison District.
And I'm Senator Terry Williams from the Rutland District.
Ann Watson from the Washington District.
And Seth Longberg from the Bennington Senate District.
And I'm sure we'll be joined soon by Senator Beck from Caledonia. And so go ahead.
Good. I assume everybody has my letter of February 8th, my email.
Yep, so it was posted last week when you sent it, so it is available to us.
Under the bill.
Okay. I don't think I should read it into the record unless you would like me to do that.
I suppose that is not necessarily needed. But anything you would like to highlight for us from that letter?
Sure. My experience is briefly described in the letter, but I've been a waterworks engineer, probably 50 years in Vermont and New Hampshire and Mass, but mostly Vermont. And I have design experience for the Barrie Water Treatment Facility, as well as Barrie and Montpelier, Waterbury, and other facilities around the state. The recreational use of the raw water supply is rather a new issue in the last, 15 years, with Berlin Pond being opened up for recreational use maybe 10 years ago. And so that was a new twist to the waterworks industry. It's very odd. I was a director of the New England Waterworks, the Vermont director, and the other directors were incredulous that we were allowing recreational use of raw water impoundments, and thinking that Vermont was a very progressive, environmentally safe state, usually erring on the side of human health. So if we look at the other states, we find that Vermont is less protected than other states, and that affects the design of water treatment plants. This was something that wasn't envisioned during the design of the Barrie water treatment plant, as well as Montpelier. Those are conventional treatment plants. They're not high-tech treatment plants. They meet the regulations, but that's all they do. So all water treatment facilities are subject to things that we really can't test for as water comes into the front door of the water treatment plant. So we're basically designing facilities that we think will encounter in the raw water. So a large-scale fishing tournament was something we didn't envision. The thing that concerns me most, and I testified on the Montpelier situation for Berlin Pond, when they were contemplating shanties on the ice, and that was a particular problem, that anything that happens in a shanty is well hidden from water operators and water professionals. So all water supply and impoundments are subject to willful contamination by terrorists, other disgruntled individuals. And so that's something we can't really well protect for, and we err on the side of overprotection by limiting recreational use. So most water systems in New England have 1,000-foot isolation around the intakes where they don't allow any use. So that's the concern. That's probably why there's no fishing tournaments in New Hampshire or Massachusetts on their raw water supply impoundments. St. Johnsbury was in a similar situation when the state allowed recreational use of their raw water source, Stiles Pond. And they were in the midst of considering alternatives to upgrade their conventional water treatment plant. And they opted to spend much more money for an advanced water treatment plant using membrane filtration. And so under the conventional treatment system, we have to remove or inactivate 99.9% of the pathogens. In St. Johnsbury with recreational use, they opted to remove 99.999. So it's called a 4 or 5 log removal operation. Much more money, but much more safety involved. Both Barry and Montpelier only remove or inactivate 99.9% of certain pathogens that we test, that we have assumed are in the raw water supply. So Barry, I guess since we're talking Barry, there's no opportunity to remove gasoline derivatives that may show up in the water from ice augers and use of the reservoir snowmobile type things. And so, if the city is too conservative protecting their drinking water from a fishing tournament, it means that they'll have to find another place to hold a fishing tournament. However, if there was a contamination event and it did occur, the health effect could be catastrophic. So I would encourage you folks to err on the side of being over conservative in protecting drinking water for the city of Barry.
Thank you. Yes, go ahead.
Thank you, Madam Chair. Thank you, Mr. Dufresne. I was scanning through your testimony, your written testimony again. And I understand that contamination from gasoline or oil derivatives, but are there other potential contaminants that might occur because of fishing in a water source?
Well, we're not really sure. If ice fishermen are out there for a day, not sure where they have their toilet facilities.
Fair.
And definitely not sure what happens inside shanties. And so there's been a lot of studies on this. It's accidental or intentional fecal release. The organisms involved are Giardia lamblia and Cryptosporidium. Those two are the most difficult for us to remove or inactivate in water treatment plant. And somebody with giardiasis during the fishing tournament could be not good.
Mm-hmm. That's a fair point. So is ice fishing more of a concern than fishing?
I think ice fishing is more of a concern because of the augers. I'm not sure what Montpelier did, whether they eliminated use of gasoline powered augers, but they should. And the other thing is if there are shanties allowed, which they are allowed on Montpelier, and they can be positioned right above the intake, and that scares the heck out of me. I'm not sure who's in the shanty, and I'm not sure what's going on because I can't see it.
And if there were a contamination to a drinking water source because of a shanty or either fecal debris or gasoline, what would you have to do as a water operator?
Well, we can't see and sense either one that's coming into the plant. To us visually, it looks like normal water from the Dix Reservoir that flows into the upper Orange and then lower Orange and into the water treatment plant. So there's no red flags that are going on, no alarms are going off. We just get this contamination event going through the facility. And our treatment is conducted as if that was normal water coming in. So if we see Giardia takes place in certain counts per 100 milliliters, and a fecal event could increase that by several orders of magnitude. And so that's something the plant's not designed to deal with. We can remove 99.9% or inactivate Giardia lamblia. However, if it's 1,000 times higher than we expected, even though we remove 99.9%, we may not get all of it.
Right. Is there a contaminant from, setting aside the gasoline issue and the potential bathroom issues, are there contaminants from fishing itself? Or is it just the people and the motors that may be there?
Yeah, I don't know of any contamination that would be related to normal fishing activities. The water works operators and officials can't really discern whether it's a real fisherman out there or somebody intent on willful contamination.
Oh, I hadn't thought of it. Wow, okay. All right, well, thank you.
Yeah, thank you. Any other questions?
Sure.
Yes, go ahead.
So I'm not familiar, I know Giardia, but I'm not sure the other part of that is that only from human feces, or would that Giardia be present with beaver and other animals that live around the ponds and lakes?
Now, the normal source of Giardia is from other warm-blooded animals, especially beaver.
Okay.
And cryptosporidium?
Crypto is maybe from, I don't know enough about it, whether it's contributed by other warm-blooded animals, but it's mostly from infected individuals with cryptosporidosis.
Okay.
So migratory birds, they could contribute to that also. Fish pool, I don't know whether that would be involved in it or not. That's all present in the water anyway. So you have to test for that to make sure that it's not above the limits.
I'm sorry, my hearing's not that good. I missed most of that.
No, I said that they're already present in the water anyway from the other warm blood animals.
Yes.
So you would have to test for it anyway.
Well, the tests are very expensive, and it may be tested at the beginning of the design of the facility, but very rarely tested after that, except unless there's an outbreak of both Giardia or crypto.
So they wait until somebody got sick before they test for it?
Yeah.
Oh, okay, thank you.
Okay, well, thank you very much. Really appreciate your testimony this morning.
Sure.
We're gonna move on to Chief Vale. That's in person. Welcome.
All right. Good luck in your decision.
Thank you.
Please don't ask me to spell any of the terms.
No worries.
So I am here to offer a law enforcement perspective for your decision that you're making. And a little bit about what he had spoken to with fishing.
Oh, and sorry, and so if you could just introduce yourself for the record.
I apologize.
No worries.
My name is Braden Vale. I go by Brad, and I'm the Berry City Police Chief.
Okay, super, thank you.
So what again, I'm offering a law enforcement perspective on this. The most recent issue, we encountered was that the state had issued a permit for a fishing derby, and they expected about, I think it was 50 to 60 individuals that were registered for the derby. Currently, the city has a policy, which I brought, I'm not sure if anybody's familiar with it, it is on our website. They do allow fishing. However, they only allow fishing from the shoreline in designated areas. They do not want watercraft on the reservoir. They do not want bait fish. I'm not sure if that must have something to do with what he spoke of. I'm not really sure there. And they do not want ice fishing. Again, it's for the augers, the gasoline, contaminants. And as with the watercraft, you could have the gasoline contaminants as well as foil coming into there. So what happened is because the state issued the permit, they had no recourse because under the conservation and the public water use rules, they couldn't deny the permit because they controlled the surface water. But the city controls all the land around the water. And in an effort to try to protect that, stop that, they said, well, we're gonna trespass people. So it put us in an ambiguous situation by, people have permits to be there, and then we're gonna be called up there to say, sorry, you got a permit, or you're trespassing, you need to leave. That's not a situation that we like to be in. So for those reasons, we support this bill. And again, the city is not trying to totally do away with fishing there. They just want those prohibitions to control the surface.
Yes, go ahead.
Do we know whether this application that scored all this is just for fishing from the shoreline, or does it involve boats, or what's?
Well, the first tournament was February 8th.
That was ice fishing, okay.
That was ice fishing. So again, it goes back to the previous testimony about the shanties. And however, the ice augers, whatever they're gonna utilize for that.
Okay.
The next one, there's already a permit for another one in June. I'm not sure the exact date. I can look at it. And that will obviously be with water.
That will, okay. Say obviously,
I would imagine. I don't know for 100% certain, but if they're opening it, people will be putting boats in.
okay,
Or the alternative is that if you have a similar uptake, then you're trying to fit 50 or 60 people on the limited shoreline to fish.
Sure.
Odd, yes.
You know how many acres the pond is?
Without looking, I'm not certain.
Because I think there's a state law that says if it's less than 40 acres, there's no motorized watercraft allowed.
Well, we can,
Yeah, I believe it's somewhere in there. I know that, I know the depth is 13 feet, and I'm not sure the acreage. But currently they have the little orange and the big orange that they don't allow any fishing, just the ducks.
yeah. Yes,
And from a shoreline security perspective, if there were, when there is a fishing tournament at the reservoir, would your department have to put people there to?
So the city would have folks there to make sure that folks were using the designated areas and not putting boats in. Quite frequently, the water treatment folks that do monitor that, they have called us when there's like, they've seen boats out on there. And when we go up there, it's hard to communicate with somebody in the boat.
Yeah,
And we can't stand there and wait for them to come back.
right,
So again, that causes a situation for us.
yeah,
We can obviously look at a registration plate and determine that potentially maybe the individual
yeah,
that's out there, but again, from a probable cause standpoint, you can't say that registered owner is the person in that boat.
right.
So it puts us in those situations.
And do you have a watercraft that you use for
We do.
enforcement?
We
Okay.
do.
Do you have a Vector? No, sorry.
Provided, I don't know.
It's fine, this is about all this from Barry by. I'm just wondering if you have, because one of the concerns that's been brought up is the expense to the city for sort of policing and cleaning up from an event, and just wondering if you have an idea of what it might cost you if.
I can't give an exact amount, but you have, obviously, we have staff that are on in the city, so we can't have them leave the city to be there.
Yeah,
So it would,
Far outside of the city.
correct, it's in Orange, which is actually state police territory where it is. But yes, we own the property, so when these events happen, the city has to.
I'm trying to visualize all of this and I.
So those would be what we call outside details, so just the manpower, for instance, this event was, I believe, from 8 to 4, the February 8th event was supposed to be from 8 to 4. So we would have to have officers on outside detail, at a cost of $100 per hour up there. Just to be there if anything came about.
Okay,
And things they would be looking at as well, even if there was, just everybody was in fishing from the shoreline. Is any litter, any other contaminants that, spillage or what people are doing in the shoreline. That could also leak into the public.
mhm.
Do you have to have, Berry City Police up there, or can anybody be up there?
Well, technically, you could hire the sheriff's department to go up there if they wanted to, or the state police, but they're not. I'll be honest, the state police and things say, yeah, we're gonna go. They've got, a large area to cover, and we're not just gonna go stand by and watch fishing.
Thank you.
Thank you. Yes, any other questions? Okay,
Thanks.
thank you so much.
Thank you.
Really
Thank you for having
appreciate it. Yeah,
I appreciate all you guys do.
yeah, thank you.
We're trying.
Well, and
Good job,
it's,
especially in today's climate.
I'm appreciating that you pointed out the difficulty with like the state had no way to say no.
Yeah, that's because the Fish and Wildlife Department is obviously follows the Department of Environment and Conservation, the public use water rules.
And the Constitution.
Correct. Yes, can't forget that.
All right, thank you so much.
Thank you very much.
It's at my end. Okay, that's fine. So, it appears that we have, a little bit of time, before we. I do wanna have some conversation about this bill and where we're going. I think probably now is not the time to do that. But I'm anticipating that we'll, have some more conversation about this. Friday, I think is the time.
Okay, Friday, 11.
Yeah,
Right.
Friday, we'll talk through I'd like to talk through all the parts of this bill, but especially the stickiest, trickiest parts. And then from that, we'll have a new draft and we'll be able to move forward. So with that, I think we can take a quick break while we wait for First Lady Gaskell. Super. All right, we're live. Okay. Good morning again. This is Senate Natural Resources and Energy coming back from a quick break. And we are jumping back into talking about Act 250, the OG. And this is round two of just learning how it works. So welcome, Mr. Kelsey.
Thank you.
I'm going to turn it over to you.
Ellen Tchaikovsky, Office of Legislative Counsel. So yes, Act 250 introduction round two. I have a few slides. It's a little bit of a grab bag.
Great.
But what I can tell you is that I went back and reread Act 250 of 1970 last night. It is only 14 pages. It is now around 250 pages. And so, which is a nice easy number to remember.
It's 250.
Yes,
Wow,
And
that is
so-
iconic.
it's quite a bit longer than it used to be. And so there's a lot of different things within it. And so here are just a couple of topics within it, if I can. All right, we're doing this. So first, I think we'll talk about the board a little bit more tomorrow, but here's some history of the Land Use Review Board. I have a strong suspicion that someone has a better written history somewhere. If anyone has it, I would like to send it to me. I would love to read it. And there's even more detail here than I missed, but this is sort of a quick history of what the board structure was since 1970. So when Act 250 was set up, there was a strong interest in having it be a local control administered program. And so there have always been district commissions made up of people from the community, and they are the ones who issue the permits. But when it was set up in 1970, there was also this board created, the Environmental Board. And they served as the administration body for the act, but they also were the appellate body for district commission decisions. So when it was created in 1970, it was 9 members. They had 4-year terms, and the chair had a 2-year term. These members were appointed by the governor. A fun little fact I found was the original members of the board included a natural science professor, an architect, a realtor, a community leader and homemaker, a county extension agent, a ski area operator, an engineer, a businessman, I don't love that phrase, but and a county sheriff. So there has always been this interest. Yes, it is a board with diverse expertise, but not fully professional. They were per diem paid. They were not a full-time board. And they had jobs with various skills.
The same $50 they get today.
That, yes,
That's
I remember
sort
that.
of sad. Wow.
5 years before too.
and 9 is a lot of people on a board that needs to make decisions where they come to somewhat of a consensus. So sometime else around there, I found back to 1980, but I'm not entirely sure when they were created. The Water Resources Board was created, and they heard appeals of water related permits, wetlands, storm water, wastewater. And so there was this sort of process outside of the natural resources with the Water Resources Board. I know very little about this. I'll look into it further because it seems interesting, but I don't know a ton about how they function. What I do know is that in 2004, the Environmental Board from Act 250 and the Water Resources Board were combined into the Natural Resources Board. And at that time, the Environmental Board, their ability to hear appeals was removed, and that was sent to the Environmental Division of the Superior Court. At that time, it was called the Environmental Court. Up until that time, the Environmental Court had existed, but they were not doing water appeals or land use appeals. They were doing mostly land use permits for municipalities and I think some enforcement. So it was a much smaller docket. But in 2004, the legislature combined these 2 boards and then transferred appeals and permits away from the board to the At the time, there was still a full-time chair with the Natural Resources Board. The members received per diem payments. And it was described in the statute that the skills required to be a board member were just skills or expertise related to environment and land use. It was pretty vague. Within the Natural Resources Board, however, they created these two panels, the Water Resource Panel and the Land Use Panel. So of the 9 members, 4 went to the Water Resource Panel and 4 served on the Land Use Review Panel. And then there was also the chair. The Water Resources Panel had rulemaking authority over water law, and then the Land Use Panel had authority over the actual permitting process.
It's, you said in the beginning, at the top of this bullet point, that they were combined into one board, but then there were 2 separate panels from that board,
Yes.
sort of like subcommittees.
Mm-hmm.
Okay.
There are people who frequent this building who can tell you exactly how that worked. I cannot. And it does seem like it was an interesting structure. I think there was also a waste panel at some point too. There were a few different structures. But there was this effort to sort of consolidate things a bit.
I appeared in front of the Water Resources Board.
You did?
Yeah, 3 times.
Wait, what?
I appeared in front of the Water Resources Board 3 times. First, class on the first, second class ice stream, and the first outstanding resource board.
But you were never on,
That was constructs and clients.
Uh-huh.
And, but I appeared in front of the original Water Resources Board.
And was that an appeal of a permit?
It was, no, because it's the rule.
It was a rulemaking.
We were
Okay.
petitioning to have them designated. And since the board has been there, it's all, nothing gets designated, what happens.
Yes.
Yes.
I am not the best historian, of
No, no,
course,
no,
but it is
no.
very interesting.
Influence the lawyers got involved, you see what happened?
Mhm.
Downhill from this.
Well, so they say. So then in 2012, the panels were dissolved and it was just the Natural Resources Board. And there was only 5 of them. So they remained in charge of Act 250 and authority over rules and permits went to the Agency of Natural Resources. So then.
Water rules, just.
Yes, water.
Okay.
Yes. Land use remained with Act 250, water went to A&R. And then, what you all may be familiar with is that the Land Use Review Board, was the Natural Resources Board was renamed the Land Use Review Board. And, quick side note, I know sometimes people don't love this name because we call it the LURB, which is just a funny word, but it is, I think, more reflective of the work that they're doing. Act 250 can be considered an environmental statute, but the community input and community protection aspects and community planning is a significant part of what Act 250 actually does. It's not just about environmental resources. It is about community planning and planning for how towns and municipalities actually look. So now is the Land Use Review Board, and it is a 5 full-time member board. They're full-time members, they're a professional board, and they have still the full-time chair. And you put more detail in the statute for what is required as relevant experience. Environmental science, land use, law, policy and planning, and development, and community planning, and a commitment to environmental justice. And then also what was created in Act 181 was a slightly different process for how they're appointed. There's now this Land Use Review Board nominating committee, which is very similar to how judges are nominated and how members of the Public Utility Commission are nominated. A group of mixture of legislators and members from the administration receive applications for people to join the board. They do initial review of the resumes and hold interviews. And they compile a list of qualified candidates to send to the governor. And then the governor appoints members from that list. They serve staggered 5-year terms. And there's the advice and consent of the Senate, which is always largely true with governor appointees. A distinction though that was added was that they're removable only for cause by the other board members. So this is a further sort of insulation from political oversight. And they still have administrative authority over the Act 250 program, but you gave them additional authority to review and approve regional plan maps and Tier 1A areas. So that's a little bit about the board. Some other things about Act 250 that we didn't touch on the other day. So last week I was describing Act 250 jurisdiction. And that centers around the definition of development and the definition of subdivision. And because the statute says if you cannot commence construction of a subdivision or development without a permit, but you have to meet the definition of development, of which there are different types of projects that would trigger that. There is some other types of jurisdiction to describe to you that you may have heard a little bit about recently. So there is amendment jurisdiction under Act 250. And that is because originally Act 250 permits, when they were issued, had expiration dates. But there was a decision in 1984, and I'm not sure if it had started before then, but there's a case from 1984 that said actually Act 250 jurisdiction, the permits are perpetual because the jurisdiction as described in the statute covers not only the construction phase of the project, but its operation and use of the improvements that are constructed. And so once a permit is issued for a parcel, it remains in perpetuity and will need to be amended if the site changes. And so there's amendment jurisdiction. If a parcel has a project on it that received an Act 250 permit, if ever there is a material change to that project, there needs to be an amendment to the existing Act 250 permit. So, and that can happen for a variety of reasons. If they want to do additional, have additional things on the site that weren't originally contemplated by the permit, or the site gets sold to someone new and they want to completely change what is happening on the site, they need to go through the Act 250 amendment process. And the trigger for that is whether there has been a material change to the land use. So the analysis for that is there must be a cognizable change that will have a significant impact on a finding or condition, or may result in a significant adverse impact on the applicable Act 250 criteria.
Yes. You have the second bullet, material change and substantial change. Are they different things or?
So. Let me see if I include the quote. They are largely the same type of analysis.
Okay.
And I'm gonna get to substantial change in a moment. So material change is the trigger for an amendment, whether something needs an amendment. On the next slide, though, there is a slightly different context that it is very similar. There's something called pre-existing development. So last week you heard from the Agency of Transportation. They have some pre-existing development. When Act 250 was enacted in 1970, this provision 6081B was added that said some existing types of development as of this date are exempt from Act 250 because they started construction and planning before this new law was passed. And so if it was exempt under the regulations of the Department of Health by January 21, 1970, or had a permit from the Board of Health, or had a bona fide pending application, all of these are 1970 dates. And then also they're specifically called out state highways that had a hearing held before June 1, 1970. All this is considered pre-existing development that probably would trigger the need for an Act 250 permit, but they are considered pre-existing development and are exempt there.
I have a question.
Is that, because I've heard a lot of people say grandfather under Act 250 because they pre-existed.
Sure, I don't think we love that phrase
No,
anymore, but
right.
sure,
So is that still the case? Or is, so Act 181 hasn't changed any of that?
correct.
Okay.
Yeah. However, this is where I'm going in this, and it applies to a bunch of different types of development. And you also added another one in 1970, which is pre-existing, a telecommunications facility that had been constructed prior to 1997. The last sentence of this paragraph, subsection B, I'm not great at making slides, I'm sorry, but subsection A shall not apply to any, shall apply to any substantial change to any of these pre-existing developments. So this provision was included that said, okay. Things that were in the planning process prior to Act 250 are exempt as pre-existing development, they do not need a permit, however. And they will, if there is a substantial change to that project, that may trigger the need for Act 250 permit. And so pre-existing development are evaluated under the substantial change analysis, and it is very similar to material change. So a substantial change is defined as any change in a development or subdivision, which may result in a significant impact to respect to any of the 10 criteria. You can hear a lot more about how this has been interpreted over the years, and I would love to do more research about it, but this is sort of, in addition to the definitions of development, if something already has a permit, in the future, if there's a material change, they may need a permit amendment. The permit amendment could be as quick as an administrative amendment, which would just say, oh, we repave the driveway, or we send the driveway shortly, like, it's a small change, here's an amendment, please grant us this quickly. Rule 34 in Act 250 governs that process of when someone needs a permit amendment or when someone is allowed to request a permit amendment, because the opposite is true. You don't want people constantly requesting to amend their permit in order to get out of conditions they don't like. So there is a threshold under that process of when someone is allowed to request an amendment. But then there's this other type of development, which is the pre-existing or development that happened before 1970. And again, just because they were exempt then, they may continue to be exempt unless there is a substantial change that would be considered a development and would have a significant impact under the criteria.
So two questions. So one, something that we've talked about is that this building has an Act 250.
Oh, yeah, it does.
So even though it pre-existed 1970.
Yep.
There were changes. And so it had to get an Act 250 permit.
It did, yes.
Yeah.
I pulled it a few years ago.
Yeah, okay. And the second thing, I'm wondering if you can go back a slide.
Sure.
I just wanna, like,
How do we do this?
like the word a cognizable change,
Mhm.
it's just very curious, like, is a cognizable change, like, we knew it was happening, like, we got, like, what is that? Or like, as opposed to an incognizable change, like something that you didn't know about? I don't know,
Yes,
I'm just curious, if there's nothing really there.
I have a strong suspicion, this leads me to another plug I have, so I suspect strongly that has been debated and there's precedent.
Yeah.
I cannot remember off the top of my head, I think though the way that it's actually been interpreted is as more of like, a change you can see.
Oh,
Did
okay.
you do something on the site that we see is now different, or did you just like change the air filters in the building? That you wouldn't have noticed.
Okay.
But did you put up a new sign right in front of the building and it's got lighting and now it's very distracting? Or did you add security lights all around the perimeter and now all the neighbors can see?
Like, we all know.
Yeah.
We can all tell it happen. Yeah.
But I'm gonna say that is an incomplete answer, and someone out there knows that there is probably some interpretation of this. And the way I would check, and if you can see that this is my desktop, I don't love that you can all see this, but on my toolbar, the first link, if I can get over there, is e-notes. So under Act 250, there is a requirement in statute that the board maintain a annotation of precedent from all the cases on Act 250 since it started. And it's called the e-notes. It is updated regularly. It was updated in January. The attorneys in the office maintain it. Sometimes when they have interns do the updating, like I did 12 years ago. But they maintain this 800-page document of precedent on Act 250 on how it's been interpreted, not only by the board, but by the courts. And so it is a really great document that has a lot of information in it that I consult regularly. And so like if we click on it right now, what I did last night is I went in there and I searched for material change. material change, and I looked up to see if there was any discussion about the difference between material and substantial change. It is a resource, I think, primarily for lawyers, but Act 250 was envisioned as a supposed to be a process for lay citizens, a citizen-friendly process for people to participate without a lawyer. And so you can just go on their website, click on e-notes, and do some research that see if anything, you can find anything related to your case. Now, everything under Act 250 is very site specific. It is not a perfect document because you need to kind of see what they have written about it, and then you can go search for the actual case and read it. So it's not just the most easy, it's not, let me take a step back. It's great. It's an 800-page document though. And that indicates that there is a lot of information on Act 250. And that's because everything is very site specific, case specific, and there have been changes over the years. But anyways, that's a fun way you can do some research on
I
Act
did not
250.
even know that existed.
Yes.
Which one's it?
So it's on the Land Use Review Board's website. It's called e-notes. Yeah, it's a searchable document. I think it's under their resources page. Yeah.
Thank you.
All right, so and then just another, when we talk about exemptions and when I'm drafting exemptions, often under 6001, there are exemptions that are phrased as things that are not considered development. So that's one way something can be exempt from Act 250 is that it's not considered development. 6081 has 28 other exemptions. But they're phrased differently. They're phrased here as no permit or permit amendment is required for the following activity. And so over the years, you have created these dozens of exemptions, and they specify that not only would this project not need a permit, if something else already has a permit and they want to change to one of these exempt uses, if it says in the statute they don't need a permit amendment, they also don't need a permit amendment. So that's a full exemption from Act 250. So then I have some information on what is a major versus a minor permit. So, and I will say the Land Use Review Board has a much better chart on this than I do, but the statute allows district commissions to determine whether or not an application for a project is a major or a minor permit. I think the data that has come out of the board recently is that there are few major permits per year, but the distinction really is just whether or not there will be a hearing on the project. So when someone submits an application, the district commission shall determine whether the application is a major application, which with a required public hearing, or is a minor application, which does not automatically have a hearing. The rule 51 says that if the district commission determines that there's a demonstrable likelihood that the project will not present significant adverse impacts under the criteria, then it could be a minor. So they look at whether or not any of the plans for the site will have a significant adverse impact, whether there will be controversy over any of the aspects of the Act 250 criteria. If there is a major, if there's a risk of impact under the criteria, there's 14-day notice for a scheduled hearing. Any hearing shall be held within 40 days of receipt of the complete application. After the hearing, the district commission shall deliberate, and they must issue a permit within 20 days of the close of deliberation. So there are all of these dates in statute that the district commissions have to follow. It doesn't usually play out exactly on this timeline because the parties who participate can request additional time or may wish to present additional evidence. The statute says that the district commission shall not close the hearing until all parties have had a chance to present their evidence. So there may need to be multiple hearings in order to accommodate that. And then the district commission has time to deliberate, and then they have to issue within 20 days after that. For minor permits, there's a statute in here that describes who needs to get notice for any type of permit application. Anyone who got notice of an application can request that there be a hearing, and so, things that the district commission view as a minor permit application, someone who got notice may request that they hold a hearing, or the district commission itself can decide after they review the petition, like, oh, maybe this is actually gonna be a major and we need to hold a permit, hearing. If they do, they have 20 days within the end of the comment period to do that. And if not, they have to issue the permit within 60 days of it being submitted. So if there's no hearing, it needs to be issued within 60 days since it was submitted, and so that's a shorter timeline than the majors. And then I'll just also throw in, there is a specific statute, 6084G, that specifies that small sawmill and logging operations have an automatic minor permit process.
Even if, but someone could still request a hearing,
Yes.
even though it's minor, it's just automatic, and that's interesting that they got that designation.
Yes, and the land use review board just did a report on wood products manufacturing and reviewed how it was going. So that is something you could hear more about from them. It's sort of an odd thing, but over the years, there's been a lot of requests on how can we support the forestry industry. And that was one idea that was enacted about a decade ago.
Interesting. Okay, interesting, Snre?
So is that there, because I know there are two different applications for active custody, there's a short form, there's a long form. Does that have anything to do with the minor or major permit application?
I don't know. So there is another, so we have majors and minors, and we also have administrative amendments, which are those sort of very short, small things that can be applied for quickly and issued immediately.
Mhm.
I am not super familiar with the actual applications. And I know that they're in the process of updating their application process, so you may want to hear about that with them.
Great. Any other questions on this? Okay.
So that was a little bit of a grab bag of stuff too.
Yeah, it's good to, I have not, I had not known technically what was the difference between a minor and a major. So, it's all part of the learning.
And the board does have a nicer chart that lays it out. So if you'd like to look at either their
Okay,
report, or they can talk to you about it, but the primary distinction is whether or not a hearing is going to be held. And if there are going to be multiple parties participating in that hearing.
Okay, so we're gonna take a break until 11:30, but before we do, I just want to preview. Sorry, 10:30. Sorry, 10:30. Before we do, I just want to preview tomorrow. So we have a short day tomorrow, because there's a joint assembly starting at 10:30. So we're gonna have you back to talk about the law of 181, sort of what was passed. And then we're gonna hear from Charlie Baker from VAPTA about some suggested changes for 325. The update to 181. So and things that are not currently in that draft. So we'll hear what he has to say tomorrow. Okay, so let's take a break until 10:30.
All right, we're live.
We've been waiting for it. It's fine.
Oh dear. Okay, good morning again. This is Senate Natural Resources and Energy, and it is still Wednesday, February 18th. And so we are moving now to S 138 about commercial pace. And we.
His edits.
Oh, great.
I'm sure we've seen them on.
Oh, I think it's fine. We're joined by Mr. Yaki, who's a board member of CPACE Alliance. And thank you for joining us.
Thank you.
And it's so we have your recommended edits, which are being passed out right now. And just to confirm, it's okay for us to post those online?
Sure.
Yeah.
I took out all my initial swear words, so I think we're pretty good.
Super. Well, thank you so much. If you would go ahead and introduce yourself and then tell us about the changes that you are proposing.
Sure. Thank you very much. And I want to thank Senator Crittenden for sponsoring this legislation and being open to some of the changes that we'd like to see in this bill. My name is Michael Yaki, Y-A-K-I. I am the senior vice president for policy and senior counsel for Petros Pace Finance. We are a CPACE capital provider, one of the largest in the country. I am also a board member of the CPACE Alliance, the trade industry group for CPACE, and I'm testifying on their behalf today. By way of introduction, I have had the pleasure of writing a good number of the CPACE statutes that exist in the country today. One of the most recent ones was your next door neighbor, New Hampshire, where I was invited to rewrite their statute as I'm hoping to help you rewrite your existing one here because it did not meet. They tried rewriting it. It did not meet the needs of how CPACE works, and now they have a program that is up and running, and we look forward to doing business in New Hampshire. If should I just go through the bill as I marked it up through here, and then we can either entertain questions as I go along or at the end, whatever the committee would prefer.
Sure. Well, thank you. I think that sounds good to just jump right in, and I'm sure we'll have questions as we go.
Okay. Well, I mean, the first thing that sort of struck me was about the requirement of having a voter approval of the creation of the PACE district. This would be, except for New Hampshire, the only place in the country that has that. And New Hampshire has now figured out that at least some parts of New Hampshire, it's interesting. Some parts did not do it. Some parts thought they needed to do it. The New Hampshire legislature is now trying to clarify that local governments have the ability to, without submitting it to the voters, have this be done. And there are a couple of reasons why. One, this is not a bond initiative. There is no public money at risk. There is no legal liability or financial liability, no full faith and credit as being pledged by a local government as a result of creating this type of program. It is purely a private financing program that utilizes the governmental power of the assessment to secure repayment, and that's important because the way this works is because it does have that governmental super security lien on title. We are able in the industry are able to access money at lower rates and over longer terms. So in some ways it behaves like public financing, it behaves like a bond. It doesn't accelerate. It can go for 20, 25, 30 years. Um, uh, and other issues that we can talk about later. But the key is that because of that, you can lend low and long, and that's sort of been the missing piece to promote energy efficiency, water efficiency, and others in this country. So I would ask you if you could please review whether you actually need to have this be a voter approval requirement or to have be done directly by local governments. And I would just add one more thing about that. CPACE is a creature of essentially private financing, where CPACE is often the last link that gets in. And what that means is that all the other people, banks, funds, equities, all really sort of ready to go to get something done. CPACE comes in, and when CPACE comes in, it has a salutary effect on the project. It's got to meet certain certain energy, water, conservation, whatever the requirements are in the statute. So usually funding for any type of project has a deadline. If there is going to be a wait or or especially a long wait for something to go through a process and get submitted to the voters, chances are that project goes away. They'll go ahead and do it with a different kind of money if they can get it, in which case the environmental benefits are kind of lost. So I would just note that we always tell communities enact CPACE when you can. When we come up with a project, we can close it rather than have to wait to see whether a local government can get it done. So that's my first comment, and I'm going to be basically talking about some of my comments and edits as we go along. On the second page, just technical things regarding the fact that we're expanding beyond energy efficiency. So some of the references to only energy efficiency need to be knocked out in favor of sort of the general broader definitions that are in the statute. There's a clarification about residential buildings of 4 or less units. That's to differentiate this from residential, but to clearly qualify multifamily buildings or other types of residential commercial facilities like assisted care, memory care, which is very much a big part of CPACE projects to date. Let's see. So that's pages 1 and 2. Page 3 is some more cleanup along the definitional aspect. Okay, page 4, page 3, just a little thing. We've heard some communities say, "Well, we don't know how to deal with resiliency. What does that mean? We don't have the technical standards to do it, and we understand that they may not." That's sort of where the program administrator comes in to sort of draw on the sort of national standards that are out there. Whether it's FEMA has a Fortify system for wind resistance. We know that various northern communities have snow load requirements, things like that. They are out there. And I don't think people should be concerned that there won't be a standard by which to measure something by when it comes to resilience. But we all know that for grid resilience and in storms and other things, there are pretty clear standards that people want to have, backup power, etc. When things get bad.
Can I interrupt?
Sure.
Thank you. I just want to make sure that I am following. So the part that you were just talking about is the deletion that runs across from page 2 to page 3. Is that right?
Sorry, I just scooped ahead to page 4.
Page 4.
Yes.
Okay, so just to clarify, and then I want to go back a minute because we're going a little bit quick. Back on page 2.
Yes.
Where we're talking about your comments on lines 6 and 7.
Mm-hmm.
This commercial and industrial buildings means any building other than a residential building with 4 or less units. Just remove any doubt that, so you're suggesting that we add a 4 or less units to
make sure that buildings larger than that which are multifamily. Yeah.
Right, would count as commercial.
Yes.
Apartment buildings. Yeah, okay. Thank you. I'm feeling good about that. Okay, so, and then the rest of page 2 and 3, you're calling cleanup.
Yes.
Or just clarification.
Yes.
Yes.
Can I ask about that though?
Yes.
On the bottom of page 2, over to the top of 3.
Yes.
You're suggesting to get rid of the quantification of energy savings?
I'm not saying that. What I'm saying is that um, B is the introductory sentence to 1, 2, and 3, and 2 and 3 have nothing to do with energy. So if you'd like to put some of that back, it would be in subsection 1 rather than in the generic introductory paragraph of the first sentence of B. B introduces the notion of the analyses that are in 1, 2, and 3, but then it goes on to say energy savings, and you're not going to be doing energy savings when you're talking about water or something. So anyway, it's a clarification.
Yep, that's helpful, thank you, because yes, that makes more sense. And then anything, I want to like speed read your comment number 5. But anything you can tell us about, on page 3, line 13, 14?
Yeah, it's just that sometimes people get a little jittery going, well, we haven't implemented resilience standards, but there are out there. You kind of know it when you see it. It can go toward, um, car parks with hardened roofing to do with snow load. It can be ensuring that people who want emergency generation systems to deal with grid resilience in case of major storms. Like I said, it's not immediately you sort of, oh, what is resiliency in Vermont? It's sort of you will know it as you define it, and that's going to be part of the role of local governments and program admins deciding these are the kinds of things we'd like to see, and it means that they may not have to engage in a long and expensive process of attempting to try and define their own code or wait for the state to do theirs, but they can move forward in a way that will reduce emergency costs, rapid response costs, what have you, in commercial buildings by making them more insulated, more tougher, more resilient.
I think that makes sense, in terms of pegging resilience to some kind of standards and making sure that there's like a broad set of things that can be pointed at.
Right. And because, and it's not, and a popular can't come in and say, I'm going to put, sweaters on my heaters. That's resilience, and they're cashmere and they cost a lot of money. No, it's something that the local government will have to decide and approve. So it's not, no one is usurping local government's role, but it's something where they can decide to develop as it goes along, or grant it on a case by case basis. It doesn't. It's not an open season that anyone claiming that having sheep is in their lawn is a resilience measure. That kind of
I
thing.
guess I'm thinking of like an example here might be, that you have to lift your electric utilities or your building's utilities out above the floodplain level.
Exactly.
Right. That would be like a local.
Right.
Okay, thank you. I appreciate that. And now I'm ready to go to page 4.
Okay, so page 4. This is an important change. What I said in a conversation earlier with Amy and to the committee is that there are any number of examples in this country where PACE statutes went to die for lack of good writing, and it's one of those things where we in the industry have to understand that the clarification of how CPACE works is important, not just for local governments, not just for us, but for the capital markets and the rating agencies that enable us to access lower capital at longer terms. And these two editions, A1, A sub 1, and A sub 2, are the sort of two critical principles of CPACE that are enunciated in every statute in this country, that it's a first and prior lien, and that it runs with the land, and that it does not accelerate nor extinguished in the case of a foreclosure, whether it's foreclosure by local government or foreclosure by someone holding the security interest on the property. But those two things are kind of key. What I crossed out are kind of the knock-on effects of one and two that are understood legally by all lawyers who practice in this industry, which is regarding transfer balances, everything like that. Rather than try and do a descriptive that then leads you to have to parse out what it really means in terms of the legalities. One and two, A sub one and A sub two are sort of the key principles of what makes a CPA statute, and everything involving foreclosures, for balances, things like that, kind of follow from that. So I left some of that in B about the impact of what non-acceleration and non-extinguishment means, but B is a more descriptive way of saying that when you foreclose, uh, whatever was billed and due and not paid is delinquent and subject to foreclosure. But unlike any other type of loan, it may be a $5 million CPACE, but if there's only $200,000 in arrears from two payments or one payment, that's the only thing that's eligible for foreclosure. It doesn't accelerate it all forward, which, by the way, banks like, because it means that when they consent to this, they understand that their secured interest in the property is only, for lack of a better word, insecure to the amount that they don't pay their annual balance. The whole shebang doesn't come and jump in front of them and jeopardize their interest in the property. But so B is a descriptive nature of what essentially how one and two work in real life.
Okay, so just to follow up on that, so are you saying that as long as you have one and two, as you're suggesting, that you could actually get rid of B and it would function the same way?
Yes.
Okay,
Yes.
but it was already here, so might as well keep it.
Yeah, let's put it this way. I didn't want to be the red ink guy. So
Fair enough. Questions about that portion so far?
I'm still absorbing.
Okay, that's fair.
Actually, I think let's make sure that B actually doesn't confuse A. Right? B still makes sense.
Like that it's not interfering with A?
Or is
no, if you were to do a court action, sir, in the prayer for relief, what is described in B, in other words, at the date that a judgment is filed, if another payment comes along and is not paid, that would be included, and that's kind of what B talks about.
okay.
I do have a question about lines 11 through 13 that you're suggesting get deleted. So if there's a foreclosure, this is, as it currently stands, the past due balance would be due, but no
Yes.
future payments. Is that implied in how this would work, or is that confusing it?
Yeah, and in fact, B kind of spells that out even more, which is that actually A is almost too limiting. Past due balances shall be due for payment, but if one becomes due during the time of a foreclosure, that would get folded in, which is kind of what B is talking about. So B is actually a better way of stating A in some ways, which is why I wanted to left some of B in there because
Mhm.
it made sense to me that to give some clarity to the court, or that would be adjudicating a foreclosure,
Mhm.
that if another payment came due during the pendency of litigation, uh, up until the date that the court order is issued, foreclosure is taken, and title is transferred. Part of that includes this, and that's actually also important to local governments because um, you want to make sure that everything is paid off um, before any title is as part of any governmental assessment, whether it's a property tax. It would be the same thing with property taxes. If property taxes became due and were not paid during a foreclosure proceeding before that person could take title, they would have to make sure that the local governments were made whole at the same time. So this is just consistent with that.
Okay, thank you. I can already tell that we're gonna run out of time. We'll get through as much as we get through before 11 o'clock. And then, we could potentially, have you back, so
Well, it's
I
let
think
yeah.
this conversation's important, so.
I think let me just talk about the, there's a lot of comments that go toward the back. And let me just start off by saying that it's really important to understand that commercial pace is a very different creature than what people may have heard about residential pace in the background of your mind. Commercial pace is very much a commercial financing transaction. It is between two parties. Um, it is not. It is usually not just someone going in and getting a loan to set up a cheeseburger stand. It's much more complicated than that. The numbers are much higher. People are represented by counsel and tax advisors and what have you on each side. In addition to that, because the statute will require, as all of them do, lender consent, you're adding a whole nother layer of outside review on a transaction to ensure that and it's in a secured lender's interest to make sure that what is jumping in front of them, which would be the PACE assessment, doesn't unduly jeopardize their um, ability to have their security interests jeopardized by that. So there's within a CPACE transaction almost a requirement of outside review by third party secured lenders already on the property to make sure that they're not going to get in trouble from the PACE assessment going in there. So there's really a very, very rigorous thing in there. And what a lot of these um, changes are, or proposals or deletions that I have, or comments, deal with the fact of you don't need to make it the governmental role to do a lot of these things. And I'd say that for two reasons. One, the more the governmental gets involved, the more local governments are going to be less willing to really get involved because it increases their duties to do it. Number one. Number two, when you increase local government role in that way, you're kind of increasing, whether you really mean it or not, their kind of liability in these decisions. Because now all of a sudden it's they're making determinations, they're making these things, they're requiring X and Y. The number of trip balls that people look at in terms of analysis come up. CPACE is a private transaction with the imprimatur of a governmental lien, provided that it satisfies the requirements under the statute. But it doesn't but because it's not governmental money, and the government has no risk with regard to that lien, all the risk in terms of it not being paid is on the private sector and on the property owner. Their need to be involved in every single document and every single review, I think is lessened, and quite frankly makes it a lot easier for them to want to be involved. I used to be a county elected official myself, and for many years, and these are written partly from my own experience of wanting to do these things, wanting to create this kind of incentive for people to do things that we want them to do with their buildings, but not necessarily have such a heavy hand of government in there that that kind of friction makes them walk away. So that's behind a lot of the comments later on in this is we can have the principles in there. We can make it a duty between the capital provider and the property owner because it's a private financing transaction. That's generally where all the duties and obligations should lie anyway. Not forcing, but placing government in there a lot of the times starts to make things create a little more friction and that friction is what deters people from wanting to do these sorts of things. So that's what's behind a lot of the other comments that you see in here about removing some of the disclosure requirements that the government wants for. You can have the disclosure requirements, but make them between the private parties, not make it the government has to be involved in creating, doing, formulating, and signing all of these things. They don't need to do that. They don't do it anywhere else in the country, but you can still have those kinds of duties in there. Just make them bilateral between the property owner and the capital provider as a requirement. And if they screw up, then they get to go at each other and not end up bringing the government in as a third party.
Thank you. I'm appreciating that. Okay, do you have a question?
Oh, makes sense, the more minister.
Yes. So do you have thoughts?
I just have to absorb all this. This is a lot of
Yeah,
information.
it's a
Yeah,
lot.
and I feel like we should have had this testimony earlier. Cause
Yeah.
now we're gonna have to have everyone back in to comment on these changes. If we decide to go with them.
Yeah. That's totally fair. So one thought is that, because I think it would still be valuable to continue to have you walk us through your recommendations. Though we are running out of time for that today. So perhaps we can have you back another time.
Great, and I would also say that for each of the senators, if their staff wants to reach out and talk to me and walk through it as well, I'd be glad to give private briefings to any staff members as well.
We
Well,
don't
thank
have
you.
staff.
I was gonna say, it's just us. Well, and-
Okay.
Small staff.
Yeah, that's true. That's true. We could have our legislative council connect with you, but would probably be good.
Yeah.
So, okay, so to be continued. Thank you so much and
Thank you.
Onward.
Okay, thank you so much. Look forward to helping you in any way I can. There's one gap in the entire country in the Northeast, and that's Vermont. And everyone in the industry is saying, Michael, come on, help us close that gap. So love to see that happen, and we'll do anything I can to help you move it forward. It's not. I have like 1 minute left, and I'm going to use it. Excuse me. It is a lot. But what I'm trying to do is not make it a lot for local governments.
Yes.
And to show how it can be done in a way that can do it. Some of the cleanup involves letting local governments and program administrators help figure this out. They're professional third-party program admins that will work with local governments to help get this done. You may or may not want a state agency involved. This gives you flexibility to either work with a state agency or work with a private third party, or let the local government do it themselves. We have lots of local governments that are doing the admin themselves because ultimately the way it's set up, when they have the appropriate protections and delegation of responsibilities to the third parties, so that they are more almost ministerial in nature to help approve these things getting through, the faster and easier it gets done. And I would just say that in the last few years, some of the smaller states with the newer statutes are doing better than the bigger states in this country. Idaho, for example, which your head may spin at this, but Idaho has done more CPACE financing since their statute passed in 2024 and was implemented this year than the state of New York has done in the past 3 years.
Wow.
And that's just Idaho, not known as a environmentally cutting edge state, but this is used by property owners as a critical financing tool. In order to do it, they have to meet certain environmental engineering, energy, or other requirements. And this is, in addition to being an energy and climate change tool, it's an economic development tool for many communities as well. So I appreciate the time. Thank you so much. Thank you, Amy, for reaching out, and I'll be glad to continue to help you walk this through and close that gap.
Yeah, thank you so much. Awesome. All right, well, we're gonna move on.
Thank you.
Thank you for joining us, Mr. Yaki. And so we're gonna move on now to, is Joey's not here?
She's off taking a phone call, I think, so yes, there's a bunch of us who are from energy committees. And I think 3 of us are on your list to speak.
Yes.
And and I think we've flipped around, I'm gonna go first.
Okay.
And I'll introduce myself.
Sure, well, and
Joey, do you wanna give a little?
do you want to
introduction first?
introduce yourself or say anything to frame this up first? Because we're, just for context for the committee, there were a number of energy committee folks in the building today and wanted the opportunity to come speak to us. And so yeah, just love to hear anything that you all have to say to us. Anything else that you want to add?
Well, just for the record, Johanna Miller, the Vermont Natural Resources Council, but a big part of my job and probably the greatest privilege is to help support the network of town energy committees. You probably know about half the communities in the state of Vermont have these mostly municipally appointed grassroots groups. They've been working for about 2 decades now, although this is an offshoot, energy committees are an offshoot of what was statutorily enabled in the early 70s when there was the oil embargo and the energy crisis, to help appoint energy coordinators and committees to help municipalities cut costs. And now these groups have been doing a lot in partnership with the state and their communities to help their neighbors and their municipalities cut energy costs, transition to more affordable renewables. And a handful of them, of the 120 plus groups in the state, are here today just to share a little bit about what they've been working on, because it's a partnership between communities and the state to meet our climate commitments, which from where we sit is also a massive economic opportunity. And so some of them are gonna speak to what they've been doing and how it relates to your work, and potentially to a couple of the bills in front of your committee or soon to be potentially in front of your committee. So thank you so much for the chance to frame it out a little bit and for these fine folks to have a few minutes of your very valuable time.
Super, thank you. Welcome. And maybe we should do a quick round of our introductions for your state.
I'm Senator Ruth Hardy from the Addison District.
Senator Terry Williams from Dalton.
Okay.
And Watson from the Washington District.
So Paul Brooks from the Bennington Center District. Scott Beck from California.
Yeah, nice to meet you all, to see you again. So my name is Linda Gray, and I'm here, I've been active in my town's energy committee, which is Norwich, since 2008. So that has been with me 18 years. So today what I'd like to do is just sketch out and give you an idea of the steps that we do, and then highlight policies, drive individual energy choices, and then comment on some of the current legislation we have. So what we do, we focus on both municipal energy use and residential energy use. We've done all kinds of different campaigns. So residential solar, we've done that since 2012. At this stage, more than half of our households in town have gone solar. We have done campaigns on residential weatherization since 2014. We do all kinds of promotions to try to get people's attention. So that's outreach at our transfer station, at our general store, on Halloween at the fire station, free ice cream, free LED bulbs. We have done progress meters on the Citgo pole that's outside the general store. And that's include knitted panels to count weatherization projects or numbered rings to count solar installations. We've done climate strike yarn bombs around town, displays at the library. We have done the window inserts community build. You guys may have heard about that in your community. We've done that for 5 years. We have an Ask a Neighbor roster, so that residents with experience can help those who are just starting. We've been involved with e-bike loan programs and EV show and tells. So, and I do want to note, much of our work has been in collaboration with other Upper Valley Town committees. So with the Solarize and Weatherize campaigns, the e-bike loans and the window inserts, the network part of VCAN, so Vermont Energy and Climate Action Network, that network part is real. And we readily copy each other's ideas and successes and promote each other's programs, organize multi-town events. So also Norwich is part of a 7-town group that shares an energy coordinator staff position, and that position is housed at our regional planning commission. The 7 towns are Norwich, Bradford, Fairleigh, Stratford, Pepper, Sharon, and Woodstock. So we put in prorated funds and get prorated hours, and the RPC covers overhead. Now on to policy. So I think it's worth noting how all the various initiatives that we energy committees promote to our towns and our residents are or were supported by the scaffolding policy. So residential solar by net metering and the whole structure of the renewable energy standard, weatherization by the very existence of Efficiency Vermont, by the incentives funded by the energy efficiency charge and our electric bill, the residential building energy code, which you could do more on. EVs were supported by various subsidy programs targeted to low and middle income households. E-bikes have been subsidized by a state incentive program. All of those policies in turn are supported by the framework of the Global Warming Solutions Act and the Climate Council and the Climate Action Plan. My observation is that the hurdles for people are time and money. The solutions are complex enough that people need guidance to avoid mistakes, and then as you do the Energy Navigators program that you talked about. Home energy action is not everybody's top priority, so they need help on that. And the structures have to be in place consistently to channel people to the test of solutions. And I want to say, you don't have to care about global warming to want to switch to clean energy. If you care about affordability and health, you'll want to make the switch. The affordability factor is because of this fundamental fact. Once you make an investment in energy efficiency and clean energy, you save money and you stabilize expenses. It's true for individual households, for businesses, for governments. And this is simply because you cut ongoing fuel costs. Fossil fuels are like single-use disposable cups, and solar and wind are like ceramic mugs. I want to take a minute to be an energy nerd, and I want to quote from somebody named Kingsmill Bond. That's a great James Bond sounding name. But he has worked as a financial market analyst and strategist for over 30 years, including for Deutsche Bank and Citibank in London, Hong Kong, and Moscow. So I'm just going to quote him. I can't say it any better than he has. So the first reason behind our clean tech revolution is physics. Just a simple point that electrotech is more efficient than fossil fuels. You can get 2 or 3 times as much useful energy from electrotech solutions as you can from fossil solutions. And I'll interrupt. Electrotech means renewable energy like solar and wind combined with electric appliances and devices. At the moment, we have this remarkably inefficient system. You put into the factory, as we're at one end, 600 or 650 exajoules, and you get around the primary energy and you burn it. As you burn it, you have these enormous inevitable thermodynamic losses of between 40% if you're in a coal-fired power station, or 50%, or if you're a car, about 75 or 80%. You can't avoid this stuff. we're pouring from our calculations, 2/3 of the primary energy into the air and wasting it. Moving to electrotech doesn't eliminate waste, but it radically reduces it. Your waste levels are going to be around 10%. For decades, we had no other solutions. We couldn't come up with anything better than fossil fuels. Now we can. That is the exciting point. And for the health part, I'll just direct you, there's a November 2025 report from Physicians for Social Responsibility, along with 11 other public health organizations. It's titled Fueling Sickness, the Hidden Health Costs of Fossil Fuel Pollution. Its top key finding was fossil fuel pollution directly threatens the health of every American. So now on to current proposals. As policymakers, your job is to keep your eye on both near and long-term problems for your constituents. Develop the practical, workable, and necessary policies that will, maybe, head them off, or at least make them manageable. So right now, clean energy, durably affordable and common sense is being short-sightedly abandoned by our federal government. So we folks volunteering at our communities say to you, please do what you can to keep the ball rolling. Don't let things stall out. On to particular topics, I want to say thank you very much for your work on portable solar. That's little, but I hope mighty. On the greenhouse gas emissions reporting and inventory bill, as one of the top 10 recommendations in the 2025 Climate Action Plan. If I may speak bluntly, it would be crazy for the legislature to not follow through. It's data collection, the agency that would do the work supports it. I urge you all to support it and support ultimately the funding for that program and the staffing. As a citizen who's worked in my town on enhanced energy plans, I would welcome solid place-based data over broad data that is extrapolated to town levels. The RPCs and the Public Service Department do the best they can, but it's so obvious that while there's real data for the electricity sector, there's only estimates for transportation and thermal. The net metering rate freeze, I think this is a simple and easy way for the state to at least partially offset the loss of the federal tax credit. There'd be no impact on the state budget and a truly minimal impact on ratepayers on the order of 10 to 20 cents a month. The energy navigators, I strongly support that. I've seen the need for this in my outreach to people in my town for at least 10 years. And I've been among the many volunteers around the state who have bombarded our Addison County colleagues with pleas to figure out how to extend the program statewide. As I said earlier, improving home energy use is complex enough that people do need guidance to avoid mistakes. And then on land use policies, I want to thank you for your work on Act 181. I think it will help us on the ground to build housing in the right places and in the right ways. And I just want to note that in my town, it's just last week, our planning commission voted to recommend to our select board to opt in to Tier 1B. And I hope the select board will vote on that and approve it next week. So thank you very much.
I've heard a lot.
Yes.
Then I'm gonna leave it, Dave Martin is next.
Thank you.
Mhm.
And welcome.
Do I follow that up? Yes, so I'm David Martin, I'm chair of the Brand Energy Committee. Appreciate your inviting us to speak to you today. This is my first time speaking to the committee, so I won't be as elegant as Linda. Or nor nearly thorough, but I do have a few things to share. I take these off to read my notes. So I've been chair of the committee for about 2 years, been on the committee maybe as a volunteer for 5, kind of lived in Brandon for 25 years. I'm 7th generation proponent. Energy efficiency has been one of the major focuses of our committee, both for the town, the municipality, and for the residents. Recently, we've done a number of things to address that. And Linda mentioned the Energy Navigators programs, and I'm actually a volunteer with them. Because our town got an EECBG grant to hire them to establish the program in Brandon, even though we're in Madison County. Everyone's jealous of Madison County. And that has been going on now since this fall, I guess, and we've done 12 navigations. I've been at half of those. And we have a goal of doing 60 navigations over the rest of this year, for the cycle of the grant, which ends the end of this year. And at least 3 of those navigations have already resulted in people doing things to address their energy costs and comfort and environmental concern, including someone's already put in heat pumps, which is pretty fantastic. I think the other thing of note, which is very recent, I got a grant through the Grassroots Fund, a small grant to distribute weatherization materials at our library. Our library has a really active library of things and provides food and other things that are ancillary to their primary purpose. And this grant is able to fund purchasing things like insulating foam and caulk and weather stripping, all those kinds of incidental items that as a person doing DIY would need. And so those are available at the library for free. We also provided as part of the grant infrared camera and indoor air quality monitor, which people can borrow just like a book. And those have been popular. The other thing that came before the weatherization material is also connected to the library, and I see the library as one of our biggest allies in all of our work. The first
Library.
we got some grants, including Climate Catalyst grants. I think one of our mini MERPs went to this. We started what's called the Toolship program, which is a lending program for electric non-equipment. It gives a chance to people who might want to try, thinking about buying it, or they might have a lawn like I used to have, which I was on 1/10 of an acre in the village, and I mowed my lawn with a real mower, push mower. But we've had 2 lawnmowers, 2 leaf blowers, and 2 string trimmers available to the public to borrow through the library. But part of that program also included creating a mobile shed, and we now have 2 because they didn't all fit in one. And it is solar powered so that the batteries for the tools are charged by the sun, and it can be parked anywhere. It doesn't have to be located as the library. Has access through the cell phone app, and that's been really popular. Prior to that, we also got a grant to give the library a couple of e-bikes, which are extremely popular in the summer when tourists are around. So the library is my #1 ally. I think, the Energy Navigator program, getting back to that, I know that I really appreciate your support for that bill. And hope to see that pass. I know that there's concerns about costs, but I think it's addressing many concerns that homeowners have that have to do, cost is one of the biggest ones that you hear when you go and meet with people in their homes. Comfort's another one. We have a lot of really old leaky houses. And so weatherization comes up almost every time, but also upgrading equipment for more efficient heating. And then some people, if they're so inclined, have talked to us about getting alternative energy sources like solar panels. And I think all of those things are much easier to consider for a resident if they're meeting one-on-one with somebody who lives in the town, knows ins and outs of all of these different organizations that work on these things, which is pretty complex sometimes, how many different organizations you have to go through to figure out what you need. And then, might have the connections to local contractors or local suppliers for what the person is looking for. One of the things that I'm hoping to do in the next year is kind of expand on the weatherization materials that we're offering at the library and develop a volunteer force of weatherization volunteers to help people use that material. Plenty of people, elderly, fixed income, they're not gonna get up on a ladder and work on sealing in their basement sill. They're not gonna do a lot of things, but if we had a volunteer force, we could help them do that. So that's another thing on our agenda. I think, of the other bills that you will be looking at, the net metering rate freeze bill, I think is another one that I'd like to see passed. I got my first solar PV system in 2008. It was just a small 6-panel system on a really old, 200-year-old house. There wasn't much options, but I was really proud to put that on my roof. And then in 2017, I ended up building a new energy efficient house and went net zero. So all of this power is coming through the solar to supply that house. And, I may be an early adopter, obviously I am, I'm kind of an enthusiast when it comes to this stuff, but I think when you look at the bottom line, solar and renewable energy sources are the cheapest form of energy generation, and having a distributed energy source is much better than, plunking it all down in one gigantic power plant. And so I think helping people to make that move as much as we can is really helpful. And everyone looks at the long-term costs. The upfront costs is now going to be harder for people because of what the federal government is doing, cutting 30% tax credit. And so the incentive of the rate for net metering is the one last thing that people can look at to help them, consider going solar. So I'd like to see that continue, but have the rate freeze for the next 2 years. So that there's, we'll take advantage of that. Last one on appliance efficiency, S191. I work in manufacturing. I work for Vernon Forge in lighting design, and I've been there for 25 years. And I know as a person in the technical side of that business, I know how it has been revolutionized by LEDs, and efficiency is a big part of that. And Energy Star, UL, all those regulatory things have made a big difference in what the industry has done. And it also has caused, some headaches along the way, but what the federal government is contemplating, rolling that back, taking the minimum efficiencies. I can only imagine that the appliance manufacturers and others are just shaking in the boots at what kind of chaos that might create, bringing in competition of really cheap products from outside the country that they can't compete with because they're making them super inefficient and cheap, or users getting product that doesn't last or is not efficient. In the end, it's not saving any money but costing more. So I would definitely support that bill in protecting manufacturers like myself, or end users who are shopping around for appliances to supply their needs. And then lastly, I would love to commend you on passing the portable solar bill. I think that's a fantastic thing, and we're probably going to do a demonstration project in Brandon with a small system to help people know about that one. Yes, excited about that. Thank you.
Fabulous. Thank you so much.
You're welcome.
And anyone else from your speaking?
Yeah.
Hey, yes. Wonderful, welcome.
Morning. My name is Jim Han. And I'm from the Dorset, Manchester area. I want to thank you for the opportunity to really speak to you. I would, of course, ask for your support, and I know you have passed part of the S170 already, but I also asked for support for H716, so that was a bit complimentary. So that you know where I'm coming from, and a solution to those who feel burdened, I want to offer the following. My brother and I started from scratch, ran a Chevrolet dealership in Manchester for over 43 years. And I'm now 45. I am a financially conservative at heart person. And I certainly understand the pressures, angst of taxes, fees, and regulations. However, I also recognize good financial investment in the use of efficient, clean energy. My two sons and I built a solar array on our building at the dealership over 13 years ago. It covered our entire bill. I looked at that effort as really expense control. As we all know, the residential solar market payback method for nonprofits, 30% tax credits for individuals have been rescinded. I question if this is really the time to further reducing the credit. Are you willing to add 5,000 or 6,000 workers of a road off to the unemployment line? And are you willing to forego the efforts of many of the small business companies who have provided clean 100% renewable power to the grid? On June 24th of 2025, helped with the installation of solar and battery installations. Vermont customers saved over $3 million in one day through their efforts. I would also remind us that we need the income tax revenue from these companies and their employees desperately. For those ratepayers who are so aggrieved by the thought of a possible, I'll call it 10 to 20 cent increase a month, and that's not a proven fact. I offer a possible solution that I feel is a win-win for all. I asked, and I think I already heard the answer, but I'll say, are you familiar with window dressers? I think I heard the answer. If not, please Google it. Window dressers.org and read through their frequently asked question section. Their simple but highly efficient product is a window insert created by an array of volunteers. Over 9,200 inserts were built in this past year in the Maine, Vermont, New Hampshire region. According to a University of Maine study test process, that will save over 760,000 gallons of fuel over its 10-year lifespan. My solution, be working for Vermonters. If every ratepayer bought one insert at an average price of $50, let's say for a 30 by 30 units, they would receive the following benefits. A $100 check from Efficiency Vermont under their DIY program. They would save up to $22 in fuel savings. I'm doing a return investment of $3.50 a gallon fuel oil in 1 year. And obviously they get greater comfort in their home and the fun of a community building experience. If they cannot afford the $50, most builds provide free inserts for those who are financially stressed. The Northshire build from Brookshire was part of over the last 5 years, depending on the county, provided over 80 free inserts just this past year to those customers, and they still save $22 a year per insert. So I say, rather than destroying an industry, residential solar, let's support a known concept that saves money for the customers, reduces fuel consumption, and makes for a more livable home. Window dressers is an easy, non-destructive solution that uses common sense to add tangible values to a home. I would be glad to try and answer any questions if there are.
Thank you so much. Any questions? Yes.
Thank you, sir. Can you just describe what a window dresser is? Is it something you put in your existing window to make it more energy efficient? Do you have
I
one?
didn't want to, one of these, I did not.
Oh,
One
cool.
was a, but in windows. So
Yeah.
that would be that hard.
That's perfect.
Basically, it's a wooden frame. Plastic. Or a wooden frame that is covered with 2 layers of plastic. And the idea is when it is set into the windows from the inside,
Mhm.
you create an airspace between the pane of glass, if it's an R1 or R3 or whatever it is. There's that airspace, and then between the 2 layers of plastic, you have another roughly 3/4 inch layer. So you add a minimum of R2 to any window that is put in the,
Got it.
and that's how they come up with the fuel.
Can you put it on a sliding glass door?
It is not done on the sliding glass, you can use it, seal it up to the window.
You can fill it up, that's what I mean.
Yeah.
Yeah.
They go in during the cold months and they come out.
Yeah.
Well, that's an interesting question, if you are an air conditioning
No,
type of people, it works just as well on saving for. For- So, that's
Just
what-
one question about them, how durable are, because you take them out in, or I would imagine taking them out in the summer months, but, and then people store them in their basements?
Yeah, they do,
Or
they put them
garages.
behind furniture,
Yeah,
beds,
okay.
that kind of.
And
thing.
how durable, I mean, it's plastic,
Yeah,
right, so do they last from one year to the next?
the normal lifespan that they say is 5 to 10 years, I
Okay.
had some in my house for 7 and 8 years.
Okay,
The only thing that I advise people, if you are a family of cats,
oh,
you would not do it. Dogs don't seem to have a problem, and if you take an item like a tennis ball and threw it against it, it'll withstand that kind of.
sure,
But a short claw or
yeah,
like that.
that makes sense,
And then we do, every year, we offer at $15 if somebody has that kind of problem, what they call rewrap.
sure, cause you use the same frame.
Use the same frame.
Oh,
I've constructed it, they're probably 5 to 10 years.
yeah,
It's
that's great.
a big volunteer effort, right?
Yeah,
Very cool.
it is,
Yeah.
it definitely is a volunteer effort, but I guess my point is, for those who are worrying about, if it is 10 or 20 cents. All right, let's call it 20 cents, for $2.40 a year. You buy the 1 insert, you're $50 a head, just another 50 a month over it. It's just 1 insert, so this whole discussion on 10 and 20 cents.
Yes, go ahead.
So I guess I must have missed it, but I'm not sure I get the connection between the solar industry. And window dressers, which is thermal efficiency.
Where I'm going with that
Yeah.
is, I hear the objection. I do solar installs
Okay.
for fun, I don't,
For fun.
for fun, I don't need, I build them for habitat.
Yeah,
So I've done 3 in Bennington, I just didn't know where I know. I have a relative who is in solar business at a much different level than I am, and I learned under him with his brother, and we did our first installation. So my point is, everybody keeps focusing on this charge that it's costing those who don't have a solar system of 10 or 20 cents. Let's stop worrying about 10 or 20 cents a month and go out and show somebody how to be more efficient and make money. I put in there, I used to make financial decisions all day long. I say, put it in insert, save $50 in the first year just from the check you get, and then you save $22 every year thereafter. Why are we worrying about a 10 or 20 cent when you're gonna put 5 or 6,000 people out of business? This is where this goes. We keep chipping away from 17, knock another 1 or 2 cents off or whatever they come up with as a credit, you will have no business customers anymore. As a solar installer,
okay.
you know, with all the small businesses, we're not talking about commercial megawatt sizes, we're talking about the mom and pop solar installers, of which there are about 5 or 6,000 in that.
Yeah, I guess I'm just not understanding how it connects to window dressers.
it's a way to offset costs. Everybody's talking about costs, I guess. I don't come here very often.
Yeah.
If at all. All I hear about is cost, affordability. Let's show how to make money.
So this, I think the point is that
This is a way
you
to do.
install these, this reduces your heating costs
Well,
to offset whatever small increase there might be on your electric costs if the solar
Okay.
you end up
rate is
positive.
reduced or cost.
So there's no affordability discussion anymore. Unless you want to kick 5,000 or 6,000 people out of work. Anyway.
Thank you so much.
Right.
Thank you. I appreciate it. And thanks for the flyers.
Yeah.
Very helpful. Okay. I just want to thank the committee for your flexibility. We're jumping around to a lot of topics today. So we're going to transition to 223. Yep, that's fair. And we do we have Mason is home with the
Sure.
said he was going to zoom in, but he's not here. Okay. So we did have some new language Mason based on the discussions we had. And I think my wires got crossed here. Actually, maybe let's take a 1 minute break just to check in as to how.
Hey Mason, we're taking a quick break. We'll be right back.
Oh, excellent. Thanks so much, Jude.
No, here you go. Okay, so thank you, Mr. Overstreet, for joining us again, even remotely. Appreciate it. We know that you did us the service of coming up with some new language based on our conversation the last time we talked about this. So wondering if you can just tell us about the changes that you have proposed, and then would like to combine that with a committee discussion, or maybe we can have a quick committee discussion afterwards about where to go next. We have our legislative council here so that hopefully we can be ready for a new draft in short order. So, or I guess I should say honestly, probably next week. But there we go. All right, thank you. I'm going to turn it over to you.
Okay, well, good morning, Chair Watson and members of the committee. Thank you so much for the opportunity to testify again on this. For the record, my name is Mason Overstreet. I'm an attorney with Conservation Law Foundation. I apologize in advance for not being able to be there in person. Our 6-year-old son has a wicked high fever, and so I'm at home. But really quickly, so based on the committee's discussion and testimony last Friday on S223, here are the 4 kind of major buckets of what I would characterize as minor revisions. I think number 1, and I'm hoping, Mr. O'Grady, he's there in person, and it sounds like he'll be able to walk through the specific language. Happy to screen share too, if that's helpful. But the first priority in that bucket or minor revision would be the agency respectfully kind of requested or made the suggestion that the bill's creation section could be tightened, basically so that it better mirrored the study group's duties. My understanding is I've been in touch with the other kind of key stakeholders who've worked on this for quite some time that the committee heard from. Everyone is supportive of that. I sent along some suggested tightening language based on those duties for the creation to Mr. O'Grady. The second bucket, which is not necessary, I wouldn't characterize it as overly complicated, but it was Senator Hardy's suggestion and recommendation to consider striking any references to federal law and the Clean Water Act. And I really I have some suggestions that I'm prepared to make, which really revolve around pretty basic strike throughs. I
just want to clarify, I wasn't, thank you, I wasn't suggesting we strike the references, but rather that we reference the freeze in where they are right now or where they were last year. That was something we had talked about last session, is kind of anytime or when we are referencing federal law, that we do it as a point in time. And I guess I would defer to Michael and lawyers about whether that's the right thing to do, but I was worried about federal law being dismantled.
Senator Hardy, that's extremely helpful, and I apologize for. I think I may have misunderstood kind of your first suggestion last week, so that's very helpful, and I will defer to Mr. O'Grady. And given that, I actually think that the language in the bill with a few minor tweaks may suffice. But I defer to Mr. O'Grady. The final remaining two kind of minor edits are the agency sent along some suggested revisions to duty number 4, focusing and tightening kind of that duty towards looking at the classification system for lakes and ponds. I also have suggested language that I've sent along to Mr. O'Grady, so happy to share screen if that's helpful. And then finally was Senator Hardy's, suggested recommendation to consider changing the study group report submission date to December 15th instead of December 30th, which is a relatively easy fix. And I feel comfortable saying that all of the kind of core stakeholders involved in this are all supportive of that, as well as the other changes.
Okay.
So I think I'll stop there and look forward to hearing what Mr. O'Grady has to say, and on standby to help or share screen in any way.
Super. Yes.
I don't know what I'm supposed to be looking at.
Okay, fair enough.
Because I have Mason's markup, but it's not the same as what was handed out to you.
I think we should look at Mason's mark. That's okay, so perhaps, so I do have Mason mark, which I can send to you. Okay.
Maybe you can show us.
Yes.
But on the point of substance, I think the only thing where I would differ from what Mason's markup has is the point that Senator Hardy just made about in the reference to the Clean Water Act. He would say something like, as it existed on the effective date of this act. And so you'd be freezing it in time as Senator Hardy referenced. There's actually other language that you passed last year and other language that's moving in the House potentially that would also address the issue, but it doesn't hurt to be clear.
Mm-hmm.
And other than that, don't have any, I don't have any points on the substance. It's really, depending on what you heard from the agency, I didn't hear from the agency, but I did see their markup and I understand their points.
Mhm. Yes, go ahead.
Well, one thing, is we have the act taking effect on passage. And so one question is, if that happens, is it possible that we could have the first meeting be on July 1st, with 6 practical, rather than August 1, so we can get it? I wouldn't recommend it. I would not recommend that because say even this has to go through the other body. It also has to go through both appropriations committees because you're allowed for compensation. You're looking at this not passing, even effective on passage, until, I don't know, late April at the earliest. And you also need to understand when you pass it out of your two bodies, that's not when it's effective. It's effective when the governor comes and picks it up. And the governor doesn't have to come pick it up. He can wait. It's just once he picks it up, he's got 4 days effectively. So when you consider all of that, you're talking probably June before it's effective, and now you have a month. And it's a lot harder to appoint people than you think it is. Yeah. Okay.
Well, and as I'm looking at it, it currently says, she'll call the first meeting of the study group to occur on or before August 1st, so it could be sooner than that. Depending on how quickly everything moves.
No, that's reality.
Yeah.
And if you want more time, you could bump the December 15th to January 15th, if that would be helpful.
Yeah.
Yeah.
Okay,
To be fair, the group exists into February of 26, and so nobody's gonna enforce the deadline against you. Okay, so you will have time to complete it.
so I do have the digital version. I'm happy to forward it to the committee if that is useful.
Maybe you could share.
Or can you share your screen with that?
I'm more than, oh, am I back? I'm more than happy to share my screen, or since Mike's right there in the room and has the draft. Mike, are you saying the reason why I placed these edits on that draft is that was the draft that A&R had put suggested edits on duty number 4? You're saying that's not the revised draft that you circulated, correct?
So the non-markup draft I have is different from the markup draft that I have.
Yeah, Mason, when you sent it to me, I gave you the long version. Because there were a couple floating around and so that's what happened.
Okay. Well, I think the good thing is, tell me if you agree, there's not a lot of substantive difference between the two drafts. So these suggested edits can be made on the latest version, and we can still share screen so you can see the language.
Yeah, let's do that.
Or Mike in the room could just walk through them since he's got the physical copy, whatever's easiest and most efficient for the committee.
That would be fine. I guess I do want to say I want to reserve a little bit of time during committee because we have a edit or amendment to 218 that we need to look at as well. So we have a little bit more to do. I don't think that that's going to take very long, but I just am conscious of the time. So, but yeah, if you're able to share your screen and we can walk through that very quickly, then I think we're hopefully, my goal is to be walking out here ready to have a new draft, like with direction to have a new draft for next week.
Beautiful. So can everyone see my screen right now?
Yep.
Okay. So bucket number 1 or revision number 1 would be the tightening of section 1A, the creation section. And here is kind of a quick recommendation is you can see where I've struck through this language in the previous draft. And then I inserted, there is created the water quality, lake classification, and anti-degradation study group, which shall conduct evaluations set forth in subsection C, including review of existing classified waters of the state and candidate waters with water quality data supporting reclassification, assessment of anti-degradation requirements, examination of the regulatory framework for Class A waters, and examination of the adequacy of the current water classification system for lakes and ponds. Based on these evaluations, the study group shall recommend to the General Assembly any legislative or policy changes to strengthen environmental protection, provide regulatory certainty, and support public uses of state waters. That would be recommendation number 1. Moving down really quickly.
Well, before any questions on that from the committee? Nope. Okay, all right, let's keep going.
Okay, so moving down really quickly, no changes to membership. This is where I'd look to Mr. O'Grady, given what Senator Hardy just said, so I apologize for kind of crossed wires there. In my opinion, I now think that personally I would avoid this suggested strike through, which I've placed right here, and actually keep the original language, but curious to hear what Mr. O'Grady thinks and recommends.
I think keep the cross-reference to the Clean Water Act. Make sure following the Legislative Council drafting manual, if you want to freeze it, you use the appropriate language for freezing it, which we can do. And okay. I think Senator Hardy's concern is addressed.
If we freeze it, I'm very good with that. I think that makes sense to do. Okay, thank you.
Okay. Really quickly, this was the suggested edit by the agency. You can see their language in blue and my suggested tightening in red, which does not change the substance here. And so this would be duty number 4. It would read, evaluate whether the existing water classification system and the related statutory and regulatory frameworks address current and potential threats to lake and pond water quality and ecological integrity and provide regulatory certainty. This ecological integrity was a suggestion that Senator Bongartz made, moving it up in the list of this sentence. So that would be that language. I realize there's a one and that should be struck through.
Yep. That also seems fine to me. With the striking out of the extra and. Any other, Senator Bongartz, you're okay with that? Yep. Great. Any other?
What really quickly in like 10 seconds, one suggestion not to derail this conversation that Mr. Warren Coleman made just this morning, which is not a must, just a consideration for the committee, is the committee could insert recreational uses after water quality here. And that's a consideration. I recognize that may tread into things related to S224, but it's just a suggestion.
Well, my initial take on that is, well, let the House figure that one out, and then it continues to be a suggestion.
Okay, and Mr. Coleman, I feel comfortable saying that he was not married to that language or suggestion. It was just an idea. So, sure. Okay, and then finally is the date change, December 15th, which we did discuss.
Okay. So, committee, I am okay with all of those changes. Understanding that we're keeping the reference to the Federal Clean Water Act, freezing it in time. Any other comments on these recommended edits?
No, so we'll see one final draft.
Okay, so we'll schedule Mr. Grady for a final draft on this next week, and a vote. Okay, any other comments, Susan? Okay, super. Thank you so much and all
Thank
the
you
best
so much.
for your little human.
Thank you. Take care.
Yes, you too. Okay, so now we're moving to an amendment that Senator Hardy and I are bringing for 218. Okay. Here, thank you. Okay, and if we can invite Mr. O'Grady up to the chair here. So just for some context, as I was preparing the floor report, in section 3, there was the very last sentence. So section 3 is about the report that we're asking DEC to do on storage of salt. And so it actually includes the old language in this instances of amendment. As it stands, it's asking them to also include a proposed amount, an annual amount of funding that would be required to meet the timelines for covering or movement. And I thought that implied that we were somehow requiring that salt piles be covered, and that is not in this bill. And so it changed it to some new language that I think makes it clearer that we're not intending to require coverage of salt piles, at least at this time. And then, Senator Hardy, do you want to explain the second one?
Sure, the second one is on the fee report, and it would just add that they would have to, in consultation with agency of transportation, recommend fees for both the private contractor portion of the program and the municipal portion of the program. And this, we actually officially voted on yesterday in finance, and everybody was comfortable with it, because this is in the finance piece section.
Anything you want to add, Mr. O'Grady?
No.
Okay. Any questions from the committee about this? I think it's just clarifying and making sure we're thorough. Okay, would love to get a vote from the committee on this. I don't know if we need to struggle. Thank you.
Yeah.
Thank you. Struggle. Great.
Yeah, we did an official vote yesterday, and Bloomberg was like, no, you didn't need to do that. In fact, you don't have the bill, you can't do that, so.
Interesting.
Yeah.
Okay.
Just to straw.
Okay,
So these are amendments you've already made and they're on the calendar.
Yeah.
yeah, so we'd be bringing that as amendment to today. Okay, all in favor, please say aye. Aye. And opposed? Okay, great. Thank you, everybody. And even with all of that,